Thank you. Thank you, Mr. Chair, and the committee for the opportunity to respond to these questions. And I'll take your the question you asked me first. Yeah. There is absolutely nothing illegitimate about doing a comparative survey of laws in other countries when you are seeking to enact legislation. I do that all the time, and there's nothing illegitimate even for a court to have recourse to case law from other countries to the extent that they lend some persuasive learning, they offer some persuasive learning to guide the court. So it is not my argument that the proponents of the bill cannot look to templates from Russia or Uganda or Moldova or Hungary. But in this debate, in the debate generated by this conversation, you continue to hear, and indeed I think one of the presenters in support of the bill, talking about websites, there's a global movement, right? As if to suggest that there is a movement perhaps only on one side of the debate, right? As if somehow they are not following. So you see this attempt.
Prof,
right.
Did you allude to the fact that the thoughts are not their original thoughts?
That I'm not in their mind to know the thoughts where they originated.
No, did you say?
Well, I do know. What I do know is that the World Congress of Families and other international advocacy groups have had. I've had conferences here, right, out of which some of these things have germinated. I'm not saying that it's not original. In fact, I made the point that I am looking to the particular mischief. You have heard it said many times. But when you ask, what is the particular mischief in Ghana here that this bill seeks to cure, you are led to San Francisco. You are led to websites. You are led to places. I asked the origin of the LGBTQI is on their website. Do you know any questioning person in Ghana? Do you know any of these persons?
Right? With all due respect, yes. Help this particular committee to make progress. The question that chairman is asking you is that your presentation, did you say thought is not the original thought?
I am unable to say the originality of the thought. All I'm saying is that this bill is not original to Ghana or homegrown. It doesn't mean that your thought is not yours. It's meaning that we have seen bills of this kind before in other places. So you can't say that. You can't say that. And in any case, let me move on. Tyranny of the majority.
Honourable members, the professor said that he didn't say it. So let's proceed. Even
play.
Yeah. Yes, I do.
Oh, is it, Mr. Chairman, is it a violation of the privileges to say a member's thoughts are not his?
No, you said you haven't said that, so let's drift away from there. Yeah, and I want you
will
to
invite me to the committee.
See, Prof, the whole thing is that this exercise that we are doing, we would want to actually get the best and do a law, make a law that will stand the test of time.
Great.
That's why we've invited you.
Thank you very much.
Now, members of parliament are also free to actually put their thoughts together,
Good.
Whether they made a research or they didn't do any research, to actually come out with a bill. And that's why I asked, if indeed you had said it, I would have said that humbly withdraw and then we'll proceed. But you say you didn't say that. So let's proceed.
So tyranny.
And then you can respond to the other questions. Yes, especially on the tyranny and
tyranny of the majority.
Totalitarian.
in my initial remarks, I explained that democracy, which is often rendered to mean majority rule, does not mean the tyranny of the majority. That whatever it is that the majority wills then becomes law or is what obtains. Otherwise, you could not actually challenge legislation before a court of law. Law that has been passed by Parliament, a decision made by a majority of the people's elected representatives. That law is challengeable. And you would find a court of unelected judges, not chosen by anybody, sitting in judgment on that law and saying it's unconstitutional. What that means is that in a democracy, you can have safeguards, including an independent judiciary, not elected by the people, that can look into an act enacted by the people's representative on the basis of majority rule and say that that law is unconstitutional. The reason we're able to do so is because in the democracy that we practice, that democracy itself is bounded by law. And the supreme law is the Constitution. It is not anybody's faith, not any majority, not even anybody's culture. It is the Constitution. Faith, culture, majority, all are subject to that Constitution. So that is the idea I am putting forth, and it is consistent with what is in the letter and the spirit of the Constitution. Much has been made of this CDD research. A CDD survey. Yes, we do surveys. We pose all manner of questions to gauge people's sentiment, what people think. When we go out and do a survey, and we ask to judge the levels of tolerance of the population vis-a-vis various categories of persons, we do that not so that the legislature would then sit and say, oh, 97% of Ghanaians are intolerant of LGBT, therefore let us criminalize them. In fact, in my view, the more reasonable meaning to put to that is, these people are vulnerable, it's a vulnerable minority, they need enhanced protection. In that same survey, Ghanaians express tolerance of a lot of things. Wife beating. Ghanaians, a majority. You can, I don't know off the top of my head.
Prof.
Wait, I'm making the point.
Prof, before you proceed, let me remind you that this is a bill coming from sponsors, and this is not a bill of the legislature. So as we speak right now, the legislature have not based any decision on your survey.
So our sponsors, so the sponsors of the bill, right, and their supporters have made much of this CDD survey. I'm saying that what that survey should tell a legislature is not that they should go and criminalize the already vulnerable minority that is facing such mass intolerance from the public. What that data should tell you is that this is a group that needs enhanced protection from people who might wish to do them harm. That's what you should read from that. It's not to go and say, oh, 97%, therefore more criminalization. Same way, our survey data that shows that a high majority of Ghanaians would tolerate wife beating. It's not supposed to signal to the state or to a member of parliament that then you go and present a law that would allow or license wife beating. That is not the use, that's not why we do these surveys, and that is an improper use of the data. Section 104. Sure, I'm aware that the bill, the special provisions of the bill do not include an attempt to amend 104. But in your memo to the bill, in the sponsor's memo to the bill, they make reference to 104, Say 104 probably needs more contemporization. It's 1960s. It's old. So let us contemporize it and bring it to the modern era. Let's modernize it. And I'm saying that the attempt at modernization has given us a bill that has defined the offense. And I'll read from the bill itself so that I may not be misquoted. A person commits an offense if the person, this is 6:1, engages in 1, sexual intercourse between or among persons of the same sex. So in terms of the conduct, the predicate offense, the conduct that leads to the offense, 1 is same-sex marriage. Same-sex sex. 2, sexual intercourse between a man and an animal, or a woman and an animal. I'm not concerned with that. It's in the existing law. I have no interest in that particular one. And sexual activity. This is the first time I'm hearing it. I guess that's maybe the thing. I don't know much about that. My interest is in sexual intercourse between or among persons of the same sex. And how do they define sexual intercourse? For purposes of this section, sexual intercourse occurs when a person penetrates the anus or mouth of another person with the penis of that person or other contraption. But mind you, this sexual intercourse has been defined in the preceding provision as creating an offense when it's committed between or among persons of the same sex. So any suggestion that this bill attempts to treat heterosexuals and homosexuals even-handedly is palpably false. In fact, the very beginning of the act of the bill tells us the act applies to these persons. Right? It tells us the category of persons to whom this act applies to a person, and it goes down the list. Right? Including who engages in a prohibited act. And that's the act that was already defined. So what I'm saying is that in moving from the existing Act 29 offense to this, we have moved from an act. What the existing law criminalizes is an act consistent with most laws generally. Criminal law jurisprudence is the act that is criminalized. By the time we move here, it is no longer just an act. It has to be an act between persons of a certain category. And that category excludes heterosexuals. It excludes heterosexuals. So, meanwhile, the unnatural and all of the things that we've heard, procreation, it transmits HIV, is presumably coming from that act of penal penetration of the anus.
I think the point is well made.
Good. Thank you.
When let me see if I can capture that the heterosexuals, they are free to live, irrespective of whether they commit any of the offenses in this proposed bill or not. And that, to you, is not fair, that they should be left free. And
because the only reason they are left free is the gender of the person they're having the sex with.
Right. So the point is well made. But I want to ask one question to you and to other speakers that have spoken on human rights. On this 104 in the Criminal Offences Act, which was passed in 1960. In 1957, we had a constitution, and that constitution provided for fundamental human rights as well. Were the proponents or the lawmakers wrong in passing Section 104 of the Act, of the Criminal Offences Act, taking into consideration the fact that there was a fundamental human right?
The 57 Constitution had a very thin provision on rights. In fact, technically speaking, it didn't have a Bill of Rights as such. Right? The protections were actually against racial discrimination more, right? So because the colonial power was leaving, had left some British people here, and this was at the time a racially mixed society in transition, there were protections against racial discrimination. It was a very, very, very thin provision. It didn't really have anything that we could call today a Bill of Rights as such, right? So the protections there were very limited and did not reach any of this conduct that we are describing here. It was, the first attempt, right? It was that absence that then led to the 69th Constitution. That's why, the Ria Koto case was trying then to read into the Article 13 interpretation.
Let's narrow it down to the 1992 Constitution.
Good.
Will you consider Section 104 to be repugnant to the 1992 Constitution?
That matter is not before us. Absolutely, it's not before us.
Article 1 says this is the basic law of the land, and any provision that is inconsistent with any provision of the Constitution shall, to the extent of its inconsistency, be null and void.
I can fashion an argument that would say that 104 as written is unconstitutional. I can fashion that argument. It is not part of the presentation that we're making here.
I get your point. Right.
So number 3, European Court of Human Rights. Absolutely. Right? And note that, notwithstanding all of the things again that have been said, nobody, I do not know, the LGBT community in Ghana, however many they may be, advocating for same-sex marriage. It is not a debate here. It's not an issue here. It's somebody else's debate somewhere. So basically, none of the supporters on our side, none of the, neither the group of 18 to which I belong, or the human rights coalition to which CDD belongs, has made much of same-sex marriage. Nobody is saying that same-sex marriage should be decriminalized. Actually, there is no debate about that. Marriage, the difference is very significant. There is a difference between sex as a private act, an inherent private act that is inherent to your being as a human, right? And marriage is a public act. Marriage is a public act. That is what the ECHR was saying to those litigants.
Permit me to interrupt you rudely. I understand you to be saying that your objection is founded in a decision to discriminate between same-sex in relation to the act of unnatural carnal knowledge vis-a-vis allowing the same act, making it permissible between people of different sex. So that if the sexual intercourse, the anal sexual intercourse, is between a man and another man, we are criminalizing it. But if it is between a man and his wife, we are not criminalizing it.
Or not his wife.
Or not even his wife.
That's right.
We are not criminalizing it.
That's correct.
That's the basis of your objection.
That is one of the basis of your objection.
That's one of the basis of your objection.
Absolutely.
And you, in effect, are saying that that selection of two men and prohibiting them is discriminatory.
Yes.
Okay. So let's now go to incest.
Mm-hmm.
Let's go to incest.
Sure.
Where two adults, mm-hmm, because they are brother and sister, or a man and his daughter, or a woman and her son, we also say that if you have sex of any form, not even anal sex, we as a state prohibit it, mm-hmm, and will punish.
Sure.
Now, why do we discriminate two adults? One is mother, one is son. And yet, when we also choose that two men shouldn't do that. Why do you have a problem with that kind of, hasn't the state been discriminating in these matters?
No. I mean, the state, so with incest, what you have with incest is you are not saying that incest between or among homosexuals is to be criminalized, but among heterosexuals it should not be. That would be the discrimination I'm talking about. But incest as incest is across the board criminalized, right? The issue then might be, why do we criminalize incest? And the issue might go then to questions of consent, right? And there are legitimate grounds. Wait.
Please allow him to.
So the issue
Prof,
with
you may
incest,
wind up now.
right? So the issue with incest then is not a discrimination question, right? The issue with incest is not a discrimination question because both heterosexual incest and homosexual incest are criminalized. The issue then will have to be something else, and it's not capacity because you are assuming that they are both adults. So what I'm saying is that from the literature that I have read, why incest continues to be criminalized in most jurisdictions is the sense that it comes close also to the prostitution argument if there's time. Remember that sex and sexual relations are not just acts. They are also power relations, right? They are also power relations. And in a family context, in the context of the nuclear family, the idea that sex between members of that nuclear family, right, are purely consensual is in doubt. It's the same reason why, absolutely, because sometimes you use an objective theory of consent, not subjective. So you can say that the same way we do with so-called defilement, which is statutory rape in many countries. It doesn't matter that the girl is 18 or 19 and is 16 or 15, but you thought she was 20 and she consented. The law puts the consent aside and said, this consent, objectively speaking, we disregard. Right? We do the same thing with incest and say that given the power relations between the parties involved in the act, any notion that this consent is legitimate is defeated objectively. We don't accept, right? So consent continues to be criminalized, right? I already spoke about prostitution. It may be consensual, but why do we criminalize? Because it's commercial sex. It's not private sex. It's commercial. In the same way you can criminalize something, you can allow something when it's not commercial, like I gave you an example, take a motorist behind your bike, you can ride with them, but the moment you charge them a fare, so kada, the state can say no kada. Right? So sex that is done as commodity, sex as commodity for commerce, can invite state regulation. That's legitimate use of state power. Right? So the distinctions that we make, and it's important in trying to separate the sins, sexual sins from sexual crimes. What are the principles that separate the sins from the crimes? These are some of the things: capacity, consent, risk of exploitation, all these kinds of things, right? So this idea that if you allow one, therefore armed robbery,